Good morning, everyone, and welcome to Eminent Domain. Is it really your property? Brought to you by Davison Eastman Munoz Peon, Association Member Trust, Citizens Bank, Focus New Jersey, Manufacturing Counts, our TV show Minding Your Business, New Jersey Business Magazine, and our podcast Planet New Jersey. I'm Katie Whitcamp, Business Development for the New Jersey Business and Industry Association. And today, Brian Keats of Davison, Eastman, Munoz, and Peon is with us. For those of you who are new to NJBIA, we are the largest statewide business association in the country, representing New Jersey businesses at the State House, advocating for balanced and sensible laws and regulations, and offering customer development opportunities like visibility through event sponsorship, magazine advertising, or opportunities on our podcast and TV show, Minding Your Business on NJTV 12. We also provide our members access to a self-funded healthcare program, a 401k solution with full administration and fiduciary oversight, an HR support platform that includes updates on legislation, sample policies, job descriptions, as well as a salary benchmark tool. Our newly designed HR Essentials products combines live HR support with over 30 digital training courses for you and your staff. Speaking of training, we also have a great opportunity coming up on October 21st on digital leadership and innovation, part of our leadership series. This is a virtual program, and I hope you can join me in that. So just a few last housekeeping items. Today's webinar is being recorded and will be emailed to you in the next few days, so please be on the lookout for that. Brian would be happy to take your questions. Please put them in the chat and he'll answer them at the end of the program. And finally, I'm happy to introduce Brian Keats. Brian is a partner in the Business Law and Litigation Department at Davison, Eastman, Munoz, and Peon, with over 25 years of experience across multiple state and federal jurisdictions. Brian has represented clients across a wide range of industries, including the construction, energy, business, commercial real estate, environmental, banking, insurance, and governmental sectors. Brian's trial experience includes serving as special counsel for the State of New Jersey Department of Environmental Protection in connection with New Jersey's Joint Beach Replenishment Program along portions of New Jersey. Brian also has experience representing architects, engineers, and attorneys against claims of professional malpractice. He regularly represents clients at mediation, arbitration, commissioner hearings, and state and appellate courts. Brian works extensively with clients in analyzing issues, forming litigation strategies when necessary, and directing a team to implement those strategies. Brian, you do a lot, but here's off to you. Please take it away.
Katie, thank you so much. I appreciate the introduction. I'm really happy to be here today. And let me start by sharing my screen here. And thank you so much for the introduction, and thank all of you for being here today. So what we're going to talk about here today, no one wants to see me for that long, right? Let's advance the screen. 1 second. Whoops. Okay, there we go. Sorry about that. So what we're going to be talking about today is eminent domain, largely in the arena of state court actions. We're not going to spend a lot of time or any time really on the federal matters. We could devote a whole nother program to that. But we're going to talk about today is eminent domain in the state court context. And you can see here on our agenda, we'll cover a few areas of this. We'll start off with some of the high level basic components of eminent domain, some of the key terms, what they mean, what the sources of authority are, and then we'll head into pre-litigation issues, seeing what needs to be done before a case ever gets to court. Perhaps it could be resolved, perhaps not, more often. So we'll talk about some of those pre-litigation requirements. Assuming it doesn't resolve there, we'll go on and talk about the complaint, commissioner's hearing, all of the litigation steps that are involved with those processes. And ultimately, if the case goes to trial, we'll talk a little bit about what's involved in that process in the eminent domain context. So starting off, eminent domain, but what does that mean? Oftentimes it's referred to as condemnation. And what those terms mean or refer to are the government's ability to take private property for a public use. And yes, they can do that under certain circumstances. It's that last term there, the public use, that oftentimes really involves the dispute when you get to the litigation phase and what that means. So one of your first questions is going to be, well, what constitutes public use? And we have guidance here from New Jersey's Supreme Court. Here we have some quotes from the Township of West Orange for 769 Associates, a recent decision from 2022. And the court informs us of what public use is. They tell us that anything that tends to enlarge resources, increase the industrial energies, and manifestly contributes to the general welfare and prosperity of the whole community, that could be a public use. That's a mouthful, so we'll look at some examples in a little bit. The court also tells us that it's not essential that the entire community or even any considerable portion of that community directly enjoy or participate in the condemned property in order for the taking to constitute a public use. And again, we'll go over some examples as to what those things might mean. So you have the public use requirement, but who can use the authority? It's a pretty significant one. So the power of eminent domain is granted through legislative action. That comes in the form of statutes or ordinances, depending on the levels of government that we're talking about. The legislature can certainly delegate that power to other agencies, and that power is actually set forth in our New Jersey Constitution. We give you the site here in Article 4, Section 6. And so some examples of entities that have this significant eminent domain power, they involve state agencies. For example, the New Jersey Department of Environmental Protection has that authority, and we provide the citation for you there. And a little bit later, we'll talk about specifically in that arena some experiences and how they've exercised that authority. Counties, New Jersey counties have the authority to condemn. Municipalities also have that authority, as do utilities. There's various statutory authorities giving those entities their condemnation authority. So if we look at some examples as to how a taking might take shape, you have a fee simple taking. It's really kind of the cleanest version of this, because there the taking authority is taking the entirety of a property, and fee simple meaning they're taking title to the entire property. For example, that might involve the authority taking a residential home in an urban environment, in particular for parking garage. You'll see parking is often a cited and acceptable public use. But sometimes they don't take the whole property. You'll hear that referred to as a partial taking. That can involve specifically larger lots. For example, I mentioned the DEP has taking authority. There's a project up and down the shore where they took partial lots. They didn't touch homes, they took partial lots. And so there you're really evaluating the value of the partial taking and then also what's left. A taking could be something as simple as an easement also. Easements can be permanent in nature or temporary. For example, we're in New Jersey, so you see a lot of construction, particularly if you're widening roadways, for an example, or doing any kind of road work. Whoever's doing that might need access to the adjoining properties, be they residential or commercial, for placement of equipment or whatever they might need that space for to get the road work done. They won't need it forever, but they'll need it for the length of time that the project's ongoing. So that would be a temporary easement, giving them the authority to use that area for whatever specified period of time there is. There's also permanent easements. For example, utilities, they need to get to their facilities. They might have a permanent easement allowing them to use a certain portion of property to access their facilities for maintenance, for repair work. Sometimes you'll see public or permanent easements for allowing the public to get to a public use space. If you check to your title reports for your properties, you might find that you actually have some utility easements on your property as well. So in New Jersey, as you may have seen, there's been some very recent examples hitting the news of condemnation in eminent domain. So let's take a look at a couple of these now and see, maybe you might be familiar with some of them. So Cranberry Township, earlier this year, there's a farm, and the township in an effort to satisfy its affordable housing um, responsibilities, decided to propose condemnation of a 21-acre family farm owned by the Henry family for purposes of constructing, I think it's 130 apartments to satisfy their affordable housing requirements. The Henry family, who's owned this farm for over 100 years, naturally, as you might expect, isn't fond of the plan and is opposing it. Um, they are challenging the suitability of the housing proposal for their particular area. You might be able to tell a little bit on the photo. It is a farm area, but it's surrounded by warehouses. The New Jersey Turnpike is very close nearby, and part of their argument is it's not a suitable location for apartments. So they are challenging that. Um, it has actually it's garnered a lot of press, as you might have seen. A lot of folks standing with the farm owners who have turned down reportedly many previous offers and the millions of dollars to purchase the property. It's actually reached its way to the Trump administration, as you may have heard, who has come down in favor vocally of the farm owner. So the part that's a very notable example of eminent domain as it's in action currently. It is being challenged, so it is something to keep an eye out to see how that one unfolds. There is another perhaps a little bit less known, but no less significant issue going on at Tom's River with the Christ Church in town. So earlier this year, our own New Jersey's own John Bon Jovi, you may know, operates the Soul Kitchen. There's a facility open in Red Bank for quite some time, and he opened one earlier this year in downtown Tom's River near the Ocean County Library. The Soul Kitchen, if you're not familiar, is a food pantry, a soup kitchen. So it opened earlier this year downtown. Shortly thereafter, in April this year, the nearby Christ Church proposed adding a 17-bed shelter for the homeless on their property. And in fact, they've applied for a variance just for that purpose. Um, that proposal may not be well received by all. So at the same time, Tom's River passed a motion to introduce an ordinance permitting the acquisition of the church, in other words, condemning it, and three nearby marinas, I believe an adjacent lot also, with the idea of converting all of that to a waterfront park with soccer fields, pickleball courts. Who doesn't play pickleball these days? All other types of recreational facilities, with the mayor being quoted as saying he thought the church would be a willing partner in that kind of proposal. Well, it turns out they're not. So they were fighting the proposal. Just recently in August, Tom's River denied the church a variance in order to construct the homeless shelter they were proposing. And the church has said that they're no longer going to pursue it, and in fact are going to abandon that plan. In the same vein, the township, Tom's River, has indicated that they're going to put their eminent domain plans, quote unquote, on hold. So we'll see how long the on hold lasts. The church has vowed to fight any effort to condemn the church property. So that's just another example of how things play out here, and how it's another area to keep an eye on to see what happens there. So with this whole eminent domain process, while there is the authority to take, the taking authority also has to pay you for whatever it is they take. And that's called just compensation, or just comp. You'll hear that phrase used a lot in the eminent domain world. And in fact, it's a right that's provided in the U.S. Constitution. The Fifth Amendment provides that, in part, private property should not be taken for a public use without just compensation. And the New Jersey Constitution has adopted that premise in Article 1, Section 20. You see it here. It says private property shall not be taken for public use without just compensation. Individuals or private corporations shall not be authorized to take private property for public use without just compensation first made to the owners. So while your property, if you're the property owner, might be subject to condemnation, you have to be paid for it. So what constitutes just compensation? Well, the easy answer is money paid for whatever the property or the property rights taken are. There's a whole process. We're going to talk about it and how do you figure out what really is just compensation. Um, as you may imagine, the property owner and the condemning authority often do not agree on the value of a property or the value of an easement or any type of property rights being acquired. But what just compensation is, though, is money paid for that. It can be money paid also for a reduction in value to whatever property is left. As I said, sometimes there's partial takings. So you'll have a determination times of the value of whatever was taken. But also there may be an argument that whatever part of property, if you're the owner that's left of mine, well, that now is worth less because I don't have at least private access to some other portion of my property. So you could get monies for the reduction to whatever is left, often called the remainder. Interest is also part of the calculation. It's often a question that people ask. Yes, you can get interest for whatever the ultimate determination of just compensation is, because that process of determining what that dollar amount is could take some time, months, years, would not be unusual. So yes, you do get interest as part of that calculation. And in sort of a formulaic way of thinking about it in a cleaner, fee simple kind of way is just compensation equals the fair market value of your property as of the date of valuation. And there's another one of those key terms in the eminent domain world that has a particular meaning, and that's date of valuation. And how do you figure out what that is? How do you figure out what the market value is? That's why you have experts and appraisers helping with this process. But the data valuation has some very specific meaning and how you figure out what that is. And we'll talk about that in a little bit. So again, in the New Jersey state court context, what governs all of this? And that's New Jersey's Eminent Domain Act of 1971. That can be found here at NJSA 20:3-1. You'll find all of the rules there. And that Eminent Domain Act governs virtually all eminent domain proceedings, including proceedings that are known as inverse condemnation actions. There is an exception that deals with the Port Authority of New York and New Jersey. They have some rules specific to them, to NJSA 32:1-77, but we could spend an entire day almost talking about that. So we're not going to go any further there because the Eminent Domain Act really governs most all procedures, including those inverse condemnation actions. And so inverse condemnation, just briefly, is another kind of unique term. And so what that means is you have a condemnation action, but it's not brought by the authority seeking to take property. It's actually brought by the property owner itself against whatever governmental agencies involved, because the owner thinks that something that has occurred outside of the property is impacting the value of their property and is in effect amounts to a taking of that property. That's called inverse condemnation. So when the property owner brings such a lawsuit, they're usually relying on one of two things, some sort of regulatory action that has occurred somewhere or a physical taking. So a regulatory example could be, I own this piece of property, the zoning has changed nearby, there's some sort of redevelopment plan in place now, something that is not directed at my property per se, but some regulatory action that is taking effect that now maybe prohibits me from utilizing my property in the way I was able to do so, and therefore negatively impacts the value of the property. Those might be grounds to bring an inverse condemnation action based on some sort of regulatory action. Second way of doing that is something, a physical taking itself. Something's actually coming onto my property from an outside source. Again, the taking entity hasn't passed some sort of ordinance or other mechanism allowing them to take my property, but rather they're doing something somewhere else. But me, as the property owner, is saying that something else is impacting my property. Physically, it's on the property. And I give you an example here: flooding on property. That is a common one that you see, that construction, something that's ongoing elsewhere has changed things, and now my property is suffering as the result. And so, yes, there are inverse condemnations, and property owners can use that as a tool to try to get some recourse. So before you ever file an action like that or a more traditional eminent domain action, there are certain prerequisites that have to be filed if you're the condemning authority. And at the forefront of those are something referred to as bona fide negotiations. So what does that mean? It means you've entered into some sort of efforts and satisfied certain requirements in the Eminent Domain Act to acquire the property without resorting to eminent domain. And you'll see that largely in ordinances that are passed that authorize some sort of municipality, for example, to take a property for a public purpose, either by negotiation, purchase, or eminent domain. So before you run to the courthouse, you have to communicate with the property owner and see if a deal can be struck. So what you'll get in those circumstances is a written notice to the property owner. They'll perhaps reference something that's passed that is allowing them. Often that'll say your property is under consideration for being subject to eminent domain. They'll ask to come and inspect the property. They'll bring an appraiser with them. The purpose of the appraiser is to form an opinion that the condemning authority can use as their opinion is just compensation to pay you for whatever's being taken. So the notice will come. You'll see here at the end the 14-day letter. The appraiser, with or without access to the entire property, will perform an appraisal, will then give a written report opining on what just comp is, will outline the methodology he or she used. And then if things still haven't progressed, the condemning authority has to serve what's commonly referred to as a 14-day letter. And what that is the authority sending a letter to the property owner offering to acquire the property for an amount that has to equal whatever the appraisal value is. If the appraiser says something's worth $100, you can't offer to purchase it for 50. You have to offer it to purchase it for whatever, at least whatever the appraisal amount is, and then provide the property owner with the appraisal itself. Once you do that as the condemning authority, you can't do anything further in terms of going to court for a 14-day period. That's why it's called a 14-day letter. After that period, if no deal has been struck, then yes, the condemning authority can then move to the next step if they choose to do so, and that's filing a complaint with the court. So if things haven't been resolved at that point and you're going towards this litigation process, what does that involve? So as you can see here, there's a complaint and other documents that are filed with it, which we'll discuss in a moment, as the initial phase of trying to take the property. Ultimately, the judge has to decide whether the taking authority is justified, whether they have the authority, whether there's an accepted public use. The judge will make that determination whether the exercise of condemnation authority has been proper. So you have the complaint in that process, and the property owner does get to respond. We'll talk about that in a second. Assuming the authority is approved and stands, then you'll have a commissioner's hearing. And there are a certain set of rules about the commissioners and who they are and what they decide. Ultimately, what they are doing is holding a hearing on what just compensation is. The story could end there if both sides are happy with whatever the commissioners decide. But frequently, as you might imagine, one side isn't pleased. It's hard to split the baby evenly once you've gotten that far to a number that both sides will accept. So oftentimes you will see that hearing award appealed to the trial court, in which case you'll then have a trial on just compensation and what that should be. So the complaint process where we start this, there's certain things I mentioned, other things you have to file, and we can see them here. So you're filing the complaint, and when you do so, you have to name all interested parties. So if you're the condemning authority, you're going to want to get your title searches going back a sufficient period of time. Maybe somebody has an easement on that property already, a utility, some other entity has one. They would need to be named. If there's tenants in the building, a house is being rented out, maybe it's an apartment complex. Anyone who has an interest in the property being condemned, or the area being condemned, has to be named in the complaint. You'll bring that complaint via an order show cause, These matters are brought in a summary manner pursuant to Court Rule 4:67. And when you're filing these, you're also going to file what's known as a declaration of taking. And that sets forth property rights acquired. It'll specify metes and bounds and everything you need to do in a typical deed. You record that with the county clerk. And in these cases, the declaration of taking does, in effect, act as a deed transferring property rights. You're also going to have to deposit funds into the court, and those funds are going to be the amount that the condemning authority offered to purchase the property, which is going to be the amount in the appraiser's report. You deposit those funds in the court. They go specifically to the court's trust fund unit in an interest-bearing account. Remember, we said interest is part of the equation, and those monies will stay there until there is some resolution. So all of those things are part of the initial filing. Now, perhaps you've heard of the term quick take. New Jersey is a quick take state. So what that means is once the governmental agency files the declaration of taking with the court and deposits the monies they're required to deposit, then title of the area that's being taken passes to the governmental agency. Now, the actual amount of the just compensation might not be decided until months or even years, yes, years later, following either a commissioner hearing or a trial. So, in other words, the owner could lose rights to the property or the property in its entirety, depending on the circumstances, long before it actually receives the just compensation. But you can imagine in the example of a roadway project, infrastructure that's needed, if the condemning authority had to wait till a determination on just compensation that's being decided, it could be years before they would be allowed on the property. So New Jersey is a quick take state. Once that declaration of taking is filed, they can start to utilize whatever area has been approved. So if on the property owner side, you get this complaint, you get these documents, what can you do? You can file your answer. You might file a motion challenging various things in the right to take. But this is your chance to challenge the taking itself. If you haven't done that here as part of your answer, part of motion practice, you're going to waive your right to do that. So a lot of the common things we see in defending against these actions are challenges to the taking authority itself. You might argue this state agency, this county, this whoever doesn't have the authority to take what they're trying to take. A more common one might be challenging the public use. The use professed to be needed for this really doesn't qualify as a public use. You'll probably in that fight revert back to the recent Supreme Court decision talking about what it means to be a public use, and there could be a debate on whether it satisfies that. You could challenge the necessity of the project. If you're taking my house to build a parking lot, but there's 50 other empty lots in town, you might argue it's not really necessary to take my property for a parking lot. Maybe there are some alternative means, and there are certainly some cases out there you can find that then sort of broach into the bad faith area where it claims there's some sort of other motivation for really taking the property. So you could challenge the necessity. And finally, another one you'll see, although it is somewhat easily remedied, is challenging satisfaction of those prerequisites I talked about, which is basically the bona fide negotiation argument. You might argue, look, they jumped the gun, they filed this without engaging in the bona fide negotiations. They didn't send me the letter, they didn't come appraise it, or they sent me the letter, but they filed the complaint before the time period expired. If those happen and the court approves it, you might be somewhat delaying the inevitable if that's your only grounds for arguing against the condemnation, because those things can be rectified, a complaint amended, a new complaint filed. But those are some of the challenges you'll see often when this process starts. And then the court makes the determination. The court will determine whether the taking authority has been properly exercised. If not, they might strike the case, and there might be an amended pleading. But if so, the taking and the right to do so has been decided. So what's left is determining that just compensation piece, and what is that, and how do we figure out what that is? So every issue that's being challenged, other than just compensation, has to be decided before you move on to this next step of the litigation process. And that next step is the commissioner's hearing. So who are these commissioners that are going to decide what just compensation should be? So what will happen is when the court, assuming they approve the taking, they'll appoint a three-person panel. And that panel is comprised of two attorneys and one realtor. One of the attorneys is to have over 10 years of experience. Now, the parties in the dispute could waive the hearing and go right to trial, and that's under the Eminent Domain Act. You see the citation there. But in practice, I would say that that is more of a rarity, certainly an exception rather than the rule, for a variety of reasons in terms of delay, wanting to get a chance to talk about or talk to the opposing appraiser in a hearing context. So you kind of get a preview of what he or she might say before ultimately a trial, but it can be waived. Now, the commissioners are also to be residents of the county in which the property being condemned is located, or actively involved in practicing in that county. The idea being you want a panel that's, in theory, familiar with the area, might be familiar with market conditions or things ongoing in the area. It is possible to proceed with two commissioners. That happens from time to time. I mean, honestly, given the amount of time that it sometimes takes to get from the order issued by the judge approving the taking and appointing the panelists to having the hearing, could be somewhat significant. I've had cases where it's been years for one reason or another. And as you can imagine, during that interval, there might be a reason why an appointed commissioner is no longer able to serve. So the parties can go forward with just two commissioners at a hearing. So before you get to the hearing, there are some rules under the Eminent Domain Act addressing what discovery is permitted. The parties are to exchange a list of their comparable sales, also known as comps, which you'll hear quite often in the context of the just compensation discussion and valuing property. So those comps that are going to be used by either side to argue what their just compensation should be are to be exchanged at least 15 days before the hearing. The idea, of course, is to avoid surprise, so each side has a chance to assess and evaluate the basis for the opposition's determination of just comp, and maybe ask some questions about that at the hearing. There's also a number of facts and information that has to be included with each of the comps you provide. And I've set them forth here just very quickly. You're going to want to give the name of the seller and the purchaser of whatever property is involved. You're going to want to give the block, lot, and municipality of the property so people can research that. The date of the sale. Date is an important factor in just comp because, in theory, the further away a sale is, perhaps the less comparable it actually is to your property and your date evaluation. You're going to have to provide the amount of money that was paid for that purchase and also the book and page of the recording for that sale. All of those go into what you're going to provide in exchange before the hearing happens. And the rules do state that no party is permitted to offer testimony of any comp that's not properly disclosed without the consent of the other parties. In practice, that does happen on occasion, particularly if there's a delay in the hearing. Perhaps there's been some new recent sale, very short term prior to the hearing date, that one or both parties find is particularly relevant because of its likeness to what's being acquired. So yeah, that does happen on occasion, that you'll be permitted to use something that hasn't previously been exchanged longer in advance. So we've been talking about valuation and what that means. So when you're determining just compensation, you're determining it as of the date of the property valuation. And what that date is can be one of several things, but it has to be one of the things set forth in the Eminent Domain Act. And as you can see here, you can find that in NJSA 20:3-20. So the date of valuation is going to be the earliest of the date of possession by the condemnation, or the date of the condemnation complaint, or the date on which the condemnor substantially affects use and enjoyment of the property. Oftentimes what you'll see is the date of complaint used, and in those circumstances, the appraiser will often, if on the part of the condemning authority, prepare an updated report. As you may recall, there'll be an appraisal report you get with that 14-day letter before the process even starts. The date evaluation there will generally be the date of the property inspection. And then when we get to the complaint phase, if you get that far, because of the requirements here, they will often update their report to whatever the date of the complaint is and use that date as their date evaluation. That might change their opinion some, plus or minus dollars, it might not, depending on market conditions and how long a time frame has expired between those two times. Maybe the market has gone up, maybe the market has gone down, maybe there have been some other sales, but you will quite often see the appraiser do a supplemental or updated report to reflect a date evaluation that is the date of the complaint. So also with valuation, you'll hear the term highest and best use used often. And what that means is whatever property or property rights are being condemned, the property owner is entitled to evaluation on the highest and best use of that property. So, which might not be how the property is being used currently. You might have a vacant lot, and it might be that the highest and best use per the permitted zoning or other factors is to build an apartment complex or build a one-story single-family home. And if that were there, the property value would increase. So when appraisers are doing this process, they will value the property given its highest and best use, whether or not it's currently being used as that or not. And in coming to their opinions, there are three very popular, widely accepted methodologies that they will use. I would say by far the most frequently used is what's known as the sales comparison approach. And basically that involves using similar properties to, let's say it's a house being taken, or even a piece of property rights with no structure on it, using other sales to reach a determination of the value of that sale. If ideally you'll want your comps in that scenario to be close in time and close in location to what's being taken, so that your opinion will be as close to, I don't want to say accurate, but will be more well supported than if you're using sales from 5 years ago or 2 counties away. So that's often how appraisers get attacked, quite frankly, on cross or is some of their comps. They might use an income approach. The income approach analyzes income producing properties. I've had motels, for example, that are subject to condemnation. So you're going to want to look at their income as part of valuing how much, how often do they rent? What are their rates? What do the other nearby motels go for? That's with an income producing property. Finally, there's a cost approach. I gave you the calculation here. It's perhaps less used than the others. It's mostly used with special purpose properties that don't come on market a lot, maybe a church, maybe a hospital, something like that. And sometimes appraisers will use two of these. It wouldn't be entirely uncommon to see sales approach and income approach, depending on the kind of property involved. And oftentimes appraisers will tell you that they're using that as kind of a check and balances kind of thing to justify what their opinion might be. And there was a significant case, it's over 10 years now, that kind of changed the way that some of these valuations were done. And that is known as the Borough of Harvey Cedars versus Karen Supreme Court decision, as you see here from 2013. And basically, the Karens on property on LBI, they're post Sandy. There was a lot of shore protection projects that were kickstarted. More money became available, and from Cape May up through Sandy Hook, there were designated projects, whether that would be adding a dune in front of properties, putting a seawall, making the beach wider. You've probably heard some of that ongoing and beach erosion issue along with it during the summer seasons if you live in New Jersey. So before the Karen case, you were really just hearing about the detrimental impacts of the taking. But for the first time, the Supreme Court said, well, any benefits, if there are any, from to a property owner from a taking have to be considered as part of the just compensation calculation. And they reasoned that the jury needs to hear both sides of the story. In this particular context, the arguments would go something along the lines of, yes, maybe I'm losing some property, some private access, but there's a value to the home because now I have this protection in front of it. When the next Sandy rolls around, I'll be better protected. So there's some sort of value to that. In conclusion, the court was concerned with a property owner receiving what it called a windfall as a result of condemnation at the public's expense. And so I happen to be involved in a bunch of trials that started after this. These were the first trials using the new Karen calculation. The Karen court actually said also that all relevant, reasonably calculable, and non-conjectural factors that either decrease or increase the value of the remaining property have to be considered. In other words, all the pluses and minuses. So what we would see in a lot of those trials were allegations that the dune, for example, which was quite tall, impacted the view of the property owner. If even from only a particular vantage point at home, that they would lose value of the property because now the dune was in place. I have less private beach to use. And in fact, the beach isn't private anymore because if you're taking public money for public use, you have to provide public access in this case. We weigh those things against the increased storm protection was the argument. Your home's still going to be there after the next Sandy in theory because of this. And so those evolve into a battle of experts with appraisers opining on just compensation, on values, and oftentimes, excuse me, with engineers getting involved to determine from an engineering standpoint what a project's benefits might be, if any, or whether it was even needed. And it was actually interesting. We would go back for jury charges, and the presiding judge down there in Ocean County wound up creating what he called the Karen charge because there was no jury charge on this issue. There were a preset of jury instructions for a lot of specific causes of action. This was unique, so we kind of molded a language taking it from this case. So that's an example of how that case quickly turned into real world experiences in the courtroom. So you get to the commissioner's hearing, and it's governed by a specific set of rules. I'll cite them here. I won't go over them all. The rules of evidence do govern the hearing itself, and there is a hearsay exception for comp sales, and by that I mean typically appraisers, they have to verify their sales and to justify their use. They'll do that often by speaking with realtors, speaking with the buyer and seller. So they're allowed to relay the substance of those conversations during the hearing. It's a hearsay exception there. If you're at the hearing, you can request a court reporter. If you do, you're going to pay for it. And procedurally, the condemning party will go first. They'll offer proof of the project and a just compensation opinion, almost certainly with the testimony of their appraiser there as well. Quickly wrapping up the hearing process, the commissioners can inspect the property under the rules, and if a party requests it, they are to do so under the rules. They can also inspect 2 of the comps. Hopefully each appraiser has more than 2. The more the better, theory being it justifies your opinion more. So they can inspect 2 of them upon request of the parties. And they don't have to have the parties present when they're inspecting them unless the parties request to attend those inspections. So after that process is done, could take a day, might take a couple days, depending on the complexities of the issues and the inquisitiveness of the panel. The commissioners are going to issue an award. They're going to offer their opinion as to what just compensation is. And in my experience, some of them fill out an order that says just comp is this with little reasoning. Some write multi-page reasonings and support for whatever it is they've determined. By rule, the commissioners are to file the award with the court within 4 months of their appointment, unless the time to do so is extended by the court. And I will tell you that that time period is quite often extended because while 4 months might seem like a lot to some, between the time the court issues an order approving the taking, appointing commissioners, you get that pre-hearing discovery done and an actual hearing and then an award. 4 months is often not enough. I've seen them extended for a period of over a year. In terms of costs, the court fixed reasonable fees for the commissioners. There's set fees. There's one lead commissioner. There's two other commissioners. Lead commissioner has a set rate, as do the others. That amount is paid by the condemning authority, which can be challenged. I've done it on occasion if it seems excessive. Once that award is out, it can certainly be appealed, so it's not necessarily the end of the story. As I said, it might be hard for a couple parties to be happy with splitting the baby. So you can appeal that. You would do that under Rule 4:73. You have 20 days to do it. It can be extended once by 30 days on a showing of good cause. Whoever the appealing party is can demand a jury trial. But if that party doesn't, the party in response could demand a jury trial as well, as long as they do so within 10 days of the notice to appeal. And if you didn't show up for the hearing, you can appeal it. So if you're one of those people that had an interest in the property that we talked about before, and you didn't show up to the hearing, you're one of the tenants, easement holder, you cannot appeal whatever the commissioner's decision is. So assuming there is an appeal, there would be a trial phase. Now, the typical discovery rules don't apply to a trial. If there's any litigators out there, depositions, interrogatories, all of those things you might see in a somewhat typical litigation don't apply here. You can find that in Rule 473-11. If you have an expert who didn't testify at the hearing, you can depose that expert. And oftentimes, one party will bring an appraiser to the hearing, but not the other, especially if it seems inevitable to go to a trial. And so you will get an opportunity to depose that expert that doesn't appear for various strategic reasons at a hearing. By rule, the expert reports can be exchanged or must be exchanged at least 40 days before whatever your trial date is. You can provide rebuttal expert reports. Those have to be done at least 20 days following receipt of the report. So you get to the trial. There's no burden of proof here. If you've watched a lot of court shows, or just typically you're familiar with a plaintiff's burden of proof, which could vary the standard depending on what the cause of action is, there is no burden of proof here. Rather, it's the parties offering their opinions and arguments as to what just compensation should be, and there is a jury charge the judge will read informing the jurors that no party particularly has the burden of proof, but they do have to convince you and support the basis of whatever they're saying. So much like the hearing, the condemning party goes first. The court here, interestingly, can allow the jury to view a property if they want. I'll tell you, in practice, the judges I've found are loath to do that for time and resources reasons. So that generally does not occur, at least in my experience. So I know that's a quick summary, but I also know we're reaching towards the end of our time there on the trial. So I'll leave you with one interesting case. As I said, it's a pretty hot topic in New Jersey and nationwide, really, that's ongoing now. So there is going up to the Supreme Court. They've already accepted this Borough of Seaside Heights case, where Seaside Park rather, and Seaside Park condemned a motel. In doing so, they passed an ordinance, and this is what's the important part and the interesting part. The ordinance says, as you see here, the acquisition will promote and protect the health, safety, and welfare of residents of the Borough of Seaside Park, and that the acquisition of the property is in furtherance of a public use and purpose. Do you see what it doesn't say? It doesn't tell you what the public use or the public purpose actually is. But despite that fact, the motel here never challenged the ordinance itself. Rather, a complaint was filed, and initially the complaint was dismissed for that very reason, for the failure to identify any type of public use or purpose in the ordinance itself. So the motel was successful in that vein. However, there were, I think, 2 amended complaints filed where, in support of the public use, the mayor provided a certification saying, well, the property is going to be used for public parking and vehicle charging stations. The court then found that that was enough. They found it was a proper exercise of authority, and now the appellate division agreed with them. They said that would be enough. So now the Supreme Court is going to take the case. And one of the key issues I think is going to be interesting to every municipality out there is if municipalities must specify what the public use is in the ordinance itself before actually condemning the property. Meanwhile, during this whole thing, the demolition of the motel has stayed and it sits there. But that's going to be something very interesting and impactful across the state once the Supreme Court does render a decision on that. And I recognize I went briefly on some topics and perhaps some quickly on others, but time flies, as they say. So with that, I'm going to thank you for your attention, turn it over to Katie and see if there are any questions.
Thanks so much, Brian. That was such great information. We did have one kind of set in that says, what happens if a homeowner decides not to respond to a written offer to acquire their property? Can they delay the filing of a complaint by doing that?
Right. And I've gotten that question often from particularly owners of residences. And unfortunately, the answer for them is no. Um, that goes back to what qualifies as bona fide negotiations. Once that 14-day letter is sent, someone might think, well, if I don't respond, I can delay and kick this down the can down the road a little bit. But you can't. The rules don't say, and the case law is developed, there doesn't have to be a back and forth to qualify as bona fide negotiations. A non-response will be deemed as rejecting the offer. So as soon as the 14 days have expired, the condemning authority can go to court.
Wow. Okay. And then could you give us an example of inverse condemnation?
Sure. I'll give you a quick example here. One I'm actually dealing with currently. I mentioned the regulatory takings and the physical takings as categories of inverse condemnation. The physical taking example, the flooding is very common. So in this context, we have a property owner who has owned the property for a period of time is alleging that some nearby adjoining roadway construction has changed the topography somehow, has changed the drainage pattern, and now every time it rains, all this water downflows onto my property. It floods it. It renders it unusable. I use it for a commercial purpose as well. It's in fact impacting my business. So you have in fact taken my property. And it is noteworthy. Case law says that you don't have the taking in that situation doesn't have to be continuous. It can be intermittent. It's obviously not going to rain 24/7. That's an example of an inverse condemnation claim where the claim is you didn't affirmatively say you're taking my property, but you did something to the road and now water dumps into my property and I can't use it. So I'm suing you for inverse condemnation.
So then one other one that was sent in to me was that you mentioned bona fide negotiations as part of the process in acquiring property. Does a property owner have to let the condemning agency own their property during that process?
The short answer is no. And there can be some different schools of thought there as to whether or not it would be advantageous to do so or not. You will certainly, if you're the condemning authority, extend the invitation to the property owner to please, be there. They'll ask for access. If it's a home, they'll ask for interior access. If it's a lot, just access onto the lot itself. They'll tell the property owner typically, please bring whoever you'd like. We'd like you to tell us as much information about the property as possible so as to allow them to account for things the owner might think are valuable and should be considered when you're determining how much this piece of property is worth. But you don't have to let them on there. And in that case, you might not want to for some reasons, or well, we'll go into those, but there might be some reasons from a strategic standpoint. You don't have to let them on. And in that case, an appraisal will take photos from the street, from a public area where they can. They'll go to records to see if it's a home, how many beds, how many baths, and they'll qualify their opinion. But no, you don't have to let them on. And it's something I suggest that you probably consult with an attorney about if you're a property owner, see how you want to handle that particular situation.
It doesn't look like there's any other questions. So to everyone, we will be sending out some information. If you'd like a copy of the presentation, we'll be sending Brian's information. You can reach out to him directly. And so until next time, for Brian with Davison, Eastman, Munoz, Payon, I'm Katie Whitcamp with NJBIA. Thanks for being part of us today, and I hope you have a great rest of your day, Friday Eve, as we were discussing before, and a wonderful weekend.
Okay. Thank you.